This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an intentional and inherently or predictably harmful conduct cannot be covered by a liability policy in the state of California, because by statute, every willful act is excluded. In a case where Markel American Insurance Company issued a management liability policy to United Talent Agency, the UTA, UTA was sued by its competitor Creative Artists Agency, CAA, for allegedly stealing its clients and employees. Markel denied coverage for the action based on the policy's professional liability exclusion and California Insurance Code Section 533, which provides that, quote, an insurer is not liable for a loss caused by the willful act of the insured. UTA sued Markel for breach of contract and bad faith. The district court held that Section 533 did not apply, but concluded that coverage was precluded by the policy's professional liability exclusion in favor of Markel. In United Talent Agency, LLC versus Markel American Insurance Company, a March 15, 2023 decision of the United States Court of Appeal for the Ninth Circuit, the Ninth Circuit disagreed with the district court's conclusion that CAA's allegations that UTA illegally stole clients and agents from CAA came within the purview of the policy's professional liability exclusion. The allegations by CAA that UTA stole clients and agents from CAA does not bring the conduct within the meaning of rendering professional services. Application of Section 533, on the other hand, is a matter of statutory construction, not of contract interpretation. Section 533 reflects a fundamental public policy of the state of California of denying coverage for willful wrongs and discouraging willful torts. Liability arising from intentional and inherently predictably harmful conduct cannot be covered by liability insurance. The Ninth Circuit concluded that the legislative purpose was both clear and unequivocal. It is to deny insurance coverage for wrongful and willful wrongs. Section 533 creates a statutory exclusion which is read into every insurance policy. The policy's requirement of a judgment establishing a willful act for the exclusion to apply is not pertinent to the 533 analysis. A willful act for purposes of Section 533 means either an act deliberately done for the express purpose of causing damage, or intentionally performed with knowledge that damage is highly probable or substantially certain to result. A willful act also includes an intentional and wrongful act in which the harm is inherent in the act itself. Section 533 precludes coverage of litigation when the allegation of the underlying complaint can be established only by showing willful misconduct. The court, therefore, is required to examine the allegations in the underlying complaint to determine whether those allegations necessarily involve a willful act within the meaning of Section 533. The district court did not do so. The Ninth Circuit therefore remanded the case for the district court to make a determination that Section 533 applies to the allegations of willful misconduct. In light of the remand, the Ninth Circuit declined to consider the parties' other contentions on appeal and reversed the grant of Markel's summary judgment motion on the professional liability exclusion, and reversed the denial of Markel's summary judgment motion as to Section 533, and remanded the case for the district court to make the appropriate determination on Markel's summary judgment motion as to the application of Section 533, because the allegations of the underlying complaint could only be proved if CAA proves the conduct of UTA was willful. If not, it's going to lose. And it is therefore within the purview of Section 533. In my opinion, liability insurance protects the insured from suits seeking damages for its liability due to the insured's negligent acts. Most liability insurance policies exclude intentional acts like assault and battery, just as did the Markel policy. California, by statute, however, compels the existence of an exclusion not written in the policy that states that there is no coverage for a loss caused by the willful act of the insured. That section applies and cannot be changed by the wording of the policy, even if the insured and the insurer wish to insure against such willful acts. They cannot do so in California, although perhaps in other states that do not have a similar statute, coverage might be required. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can also subscribe to the blog and you will be informed of every blog posting, usually 5 a week, sometimes 6. And you can also subscribe to the videos on rumble.com or on youtube.com. And if you found this video and or the blog posting to be of interest or useful to you, please tell your friends and colleagues so that they can also subscribe to the blog and to the videos. And you might also, if you want further information about insurance law and insurance claims, consider subscribing for a small fee to my Locals community or my Substack publications. Thank you for your attention.